I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my supremely patient co-host, Brett.
Oh, that's not true, Alice. I'm never patient. I'm trying to work on my patience. It's one of my things.
Well, I hope y'all are patient with us today because a lot has happened this season of the Supreme Court. Court. And we're going to do our best to fly through it because that's the only way to get through some very dense, I don't know. What's the word for tens of pages of opinions? Hundreds of pages of opinions.
Any of these opinions we're going to talk about today could have been sort of the main opinion. The opinion that you spent a lot of time on. So there were a lot of really interesting things that came out of the Supreme Court. So I'm looking forward to this discussion.
So, if you can't tell, because each of these cases can take an entire episode, we are not getting into the ins and outs, whether they were wrong, whether they were right. We are trying to give you a baseline by which to understand a lot of the articles that you may see out there talking about regulatory law, talking about the Second Amendment, talking about prosecuting a president, sitting president, or former president, things like that, which obviously we're seeing a lot in the news. So we're not getting into politics. We're not getting even really into whether these were rightly or wrongly decided. But I think it's important to understand the basis of these reasonings so that when you hear whatever side of the news is talking about what side of the world is falling, what side of the sky is falling, you have a basis of understanding what they're talking about. So that's our caveat. We are not going into deep admin law or deep executive branch law here. We are trying to give you an overview.
Exactly. And I think we should start with the best case that came out of the Supreme Court. Loper Bright. Now, as you guys may recall on episode 104, one interesting thing, we've already covered a lot of these cases, and I'm just going to say we kind of nailed it every time we talked about a case. On episode 104, we talked about the Chevron doctrine and how it was going to go away in a case called Loper Bright. And wouldn't you know it, in a 6-3 decision, the Supreme Court overturned Chevron and said an incredibly controversial thing, that courts must, quote, decide legal questions by applying their own judgment. Now, you might not think that's controversial, but if you don't, you should go back and listen to our Chevron doctrine episode. Up until Loper Bright was decided, there was a doctrine in the United States, in the courts, that basically said courts are supposed to defer to the administrative state. If the administrative state says, hey, we interpret a statute a certain way, the court, even if they thought they were wrong, even if they thought what the agency was doing was effectively illegal, they were supposed to give deference to that agency. This has been a doctrine that has been under fire for a long time. The last time the Supreme Court actually relied on it was in 2018, and this was sort of the inevitable end of Chevron. So what does the end of Chevron mean? There's a couple things. Number one, the court explicitly said that prior decisions based on Chevron deference are not going to be overturned. This is a change in interpretive method, so it's not like every case that was ever decided is suddenly open again. They're not doing that. But going forward, when you have questions of law, when you have an interpretation of a statute, courts are going to do in administrative law cases what they do in every other kind of case. They're going to look at that law, they're going to determine what the law means, and they're going to apply it. Now, the criticism here is that this will make it harder for the administrative state to function. It'll make it harder for administrative agencies to do things. Is that true? I mean, yes, it's true to the extent that before, administrative agencies were doing things that the statute did not authorize. If administrative agencies were doing things that the law did not allow them to do before this opinion, they could say, hey, it could allow it. And if it could allow it, you should say it does. Now they're actually going to have to convince a court that they have been given the statutory authority by Congress. And I would just say, I don't think that's a bad thing. And I think generally speaking, when people talk about expediency when it comes to the law and things like this, I get a little nervous about it because those are the same arguments people make whenever they want to subvert democracy, representative government, and say, hey, wouldn't it be nice if the government could just do these things without all these pesky checks and balances? Wouldn't that make it much easier for them to solve problems? That, to me, is the road to tyranny, and I like the fact that the courts have reasserted their authority to say, hey, you can do things, you can pass regulations, but number one, you need to color within the lines. You need to do what you're actually allowed to do by Congress. Number two, Congress needs to pass laws that specifically delegate powers, which they can do, to the extent that you're worried about agencies and their expertise being hampered by this. Congress just needs to pass laws allowing agencies to work within their expertise, which are the kind of things that need to happen through a democratic process. Do we have a problem in Congress right now with people not doing anything? Absolutely. But that is a deeper problem, and it is not one that is best solved by just saying, well, since people can't figure it out, here's to you, our administrative state betters, solve our problems for us.
And that's the really good point right there, right? We have the separation of powers in the United States, the three branches of government. And the argument you often hear from people is that, well, Congress is always deadlocked. It's so hard to move anything through Congress. Have you read, name your favorite law? It's not going to be a 2-pager or a 1-pager. It's not even going to be a 20-pager. It's going to be a multi-100 pager where no one's read it. No one knows what's in it. A bunch of pork is stuffed in. Yes, partly our founding fathers recognized that there was going to be a lot of stalemates and it was going to be difficult to pass these laws. And that, in essence, is kind of a feature, not exactly a bug. Some would say it's gotten worse today. We can argue about whether that's the case. But the whole point is just because one branch seems to be breaking down doesn't mean you can then shift the powers to another branch. Because once you do that, you essentially eliminate a branch and then you're down to 2 and then you're down to 1. And what is 1? The tyranny that we fought a war over and became an independent country over. And so we can talk about this even more. But obviously, what happens when you ask someone to stop doing their job? They just never do it, right? So how is the legislative branch ever going to do their work if they're never asked to do that? And some people, the argument you're going to hear often is, well, now it's activist judges. Well, honestly, before there was no appeal when there was Chevron deference, because the appeal would have been the courts, but the courts were told there's no appeal. We can't look at this de novo being in the first instance, seeing if it even made sense to have this interpretation. So these judges weren't even able to judge what was before them, and there was no appeal of what that agency thought was the case. Now, as we've talked, there's going to be, judging happening. A judge doesn't sit alone. The district judge, sure, there's one judge. There's an appeals process as well. Bigger, deeper question about what you think about the appeals process, but don't be fooled in thinking that it was more democratic, I should say, because there was really no appeal before. At least now, if you get in front of an activist judge, there is an appeals process, and it goes more than one level above that judge's head. Obviously, we've talked more in depth about this in 104. You're going to hear a lot of people saying, the sky's falling, the sky's falling. That's going to be a theme with all of these cases. Guess what? This is going to be a theme with almost any case. Whether or not it's split, it could be a unanimous decision. Someone is probably going to find an angle that the sky is falling. This is not coming out of the blue. We are not amazing psychic readers who, in episode 104, could tell you that Loper Bright was going to overturn Chevron deference. This is a long time coming, in the sense that the courts have made overtures of it, have said explicitly that they plan to do this in the future. And so this is not something, if you've been watching administrative law cases and the life of Chevron deference and similar like cases, to know that this was kind of the end game. And if you are surprised by this, it's simply probably because you haven't been following administrative law. So that's part of the sky is not falling either, is people have known this is the case. And we've actually been having to argue as lawyers in administrative law something other than Chevron deference for the past 8 years or so, 6 or 8 years. And we already knew that at the highest levels of courts, we couldn't really rely on Chevron deference anymore. We had to color inside the lines and point to the text of the statutes to explain why the regulation fit within those bounds that were passed by the legislature, or not if you're on the other side.
And the irony is the argument that's often used for Chevron deference is we should defer to the expertise of the agency, but who has the expertise in interpreting the law? The courts do. The agencies also have an interest in interpreting the law to give them the most power. That is their interest. And when they do that against people like in Loper Bright, who are just ordinary people, those people all of a sudden are at a deficit. They're at a disadvantage. They can say, look, how can you say this law means this? It so clearly doesn't. And they say, well, sorry, we're the agency and we get deference. So you're going to have to do better. And to me, I am not convinced by arguments that all of a sudden it's going to be harder for agencies to regulate because now they're going to have to follow the law. Yeah, they're going to have to follow the law. They're going to be limited by the power that was actually given them by Congress, not by power that they have accumulated to themselves. This is not a negative thing. And guess what? If you want to give them more power, you can pass the law. And if you can't pass the law, maybe that says something about what you want to do and that you've been accomplishing it up to this point through regulatory tyranny, essentially, and not through getting votes, garnering support, convincing people to do what you think they should do. And this power accrues to whatever party is in power at the time, whoever's in the executive office. This is a nonpartisan thing because when you're in charge, you love Chevron deference because then you can overturn all the stuff the last guy did. And you can do it just by saying, sorry, we're in power now. We're the agency now. We get deference and we say that was wrong. Now you're going to have to convince judges that you are actually right about what the law says, not just we're right because we say so.
And like we said at the beginning, this is just but one of many cases we plan to cover today, so we will move on. But one really quick note is to remember that the judicial branch also does not stand alone. Remember 3 branches of government and the checks and balances? Of course it will take time, but judges, though they are federal judges, are appointed for life. They do have to be confirmed by the Senate. Okay, your vote has a say in that. And you can see over time, there are certain factors that people really care about in their judges. Those types of judges don't make it through, or they do make it through. And so, of course, it'll take time, but your voice can be heard. It's not like the judicial system stands alone. There is this kind of not complex, actually. It's really not complex at all. This leaning on each other sort of situation in terms of the checks and balances, and they take time to weave through. But it's not that because this is on the judicial branch now, and by the way, I don't think it is. It's really on the legislative branch, that you have absolutely no say. That's the whole point of the checks and balances of the 3 branches. Okay, so if you are like steaming mad, turn it off. Go read some articles about Loper Bright, but we are going to cover some other cases as well.
And the next one is SEC versus Jarchese, which is a case that probably did not make as many waves, but nevertheless was also important for what it said. Basically, the holding was that the SEC could not use in-house proceedings with in-house appeals without a jury to impose fines in securities fraud cases. From now on, if you want to have fines for securities fraud, you're going to have a jury to say that should happen, which may seem obvious to you, but administrative agencies, once again, often have their own judges, their own quote-unquote juries, their own appeals processes, and in a lot of different areas. The SEC just happened to be the one that was the heart of this case. This will be really interesting because enforcement actions, now they'll actually have to convince a jury of something, which once again, they are upset about because it will make it harder for them to do the things they want to do. And I don't know. I kind of feel like under our system, if you want to take away people's property and accuse them of fraud, maybe a jury should say that you did it. Maybe that's crazy, but that's what the law is going to be now after Jarchese.
And this is something that has come up in lots of other contexts. It's going to come up in the next season of the Supreme Court. It's something that we see pop up again and again. I don't think the genesis of these administrative actions are nefarious in any way. Kind of like Brett was saying, a lot of these things are happening. And guess what? When you don't have to go to court, court takes a long time. That's the most common thing I hear from my clients. What can we do to speed the courts up? The answer almost always is nothing, right? The court system can take a very long time. And so administrative agencies, especially if they're trying to prevent securities fraud or like the SEC is trying to do with these fines, they create these administrative processes because they're like, we could fly through it. What could be bad about it? And then obviously over time, we kind of see the intricacies of, well, there is a reason that we developed or adopted a jury system to begin with. And these agencies who may try to streamline these processes that may have taken a long time because courts take a long time, we can't do that in every case. It's not all about expediency. It's about the process of due process, even if it takes a long time to be able to take away things that belong to you, including money, not just your life. Heard about the right to a jury in the criminal context. And this is the same idea where it's your personal property, life, liberty, all that stuff can't be taken away from you without due process. And the courts are saying, we get to have a role in this, not just the administrative state. Like I said, this is going to come up again in other contexts, not just the SEC, even in this next term, the next season. I'm going to just adopt that and call it the next season because it makes it sound so much more exciting.
Yeah, I think Jarchese actually may be one that ends up being pretty influential in a lot of ways.
I will say it has already affected like my work, right? Because this obviously affects the SEC directly, but all other agencies that have enforcement actions administratively, obviously, this is like a huge whistle. They have to look and see, are we going to be overturned? Is this legal? What's going to happen next?
And I think most people out there probably don't even know there are administrative enforcement actions that look like criminal actions, but aren't. Even though, millions of dollars can be on the line, your livelihood can be on the line, your business can be on the line, but
your property,
your property,
your land,
but before
titles,
your land, titles, homes, all sorts of things. But before Jarchese, you basically had to go hat in hand to the agency that was prosecuting you and try and convince them that you were right.
Which, having worked in the government for a long time and also having been on the other end and trying to file like audits and whatnot, trying to respond to government action, it can be incredibly frustrating when you feel like you have no recourse speaking into the void of the government. And this is trying to give that power back to at least an arbiter who is not entrenched within an agency, who may not have to answer politically or accountably to the people. Okay, let's stay on kind of this theme of federal agencies. We're not beating up on federal agencies, but some may say that the Supreme Court is. So in Corner Post, it was a 6-3 decision, and this stated, this is actually pretty important too. It says the window to challenge an action by a federal agency, a 6-year statute of limitations, begins to run when the plaintiff is injured, even if that injury comes along after the action occurs. So this is all about statute of limitations. Almost all laws, as we've said, there's not this infinite statute of limitations. You have to bring your action within a certain amount of time. And this goes directly to when you start counting that time.
Yeah. And so imagine this, because this is the way this goes down a lot of times. So large corporations love regulations. And you may think that's strange, but here's the thing about large corporations. They can afford to comply with regulations. Guess who can't? Their smaller competitors. The people who are going to come along and challenge them often can't afford to comply with regulations. So what you'll see, ironically, a lot of times is large companies supporting a regulation, working with the regulatory agency to craft that regulation. So imagine that like all these, the big players in the game get together and agree, we're going to craft this regulation, and then they don't challenge it because they're happy about it. And then 10 years later, you come along and you start this upstart, disruptive entity that's going to challenge the big players in the game. And all of a sudden, you're seeing all these regulations that are keeping you from being able to grow, and you can't afford to deal with them in the ways that like the big banks or the big credit card companies or the big tech companies can. Well, before this rule, it's like tough. Sorry, it's been 6 years since the regulation came down, statute of limitations passed. True, you had no reason to challenge it before, but tough luck. Now, you will be able to challenge that and say, look, it's affecting me for the first time, so I should be able to challenge it. It's kind of like a statute of limitations in a criminal case. Just because the law was passed 50 years ago, if I'm being accused of the crime today, there should be a statute of limitations there. And what you're not going to see is this won't reopen cases that have already happened. So, for instance, if a case is challenged, like imagine a regulation is challenged, it goes away to Supreme Court. Supreme Court says, that's good. Well, you may try and challenge that later on, but the court you're challenging it in will say to you, sorry, not going to happen here's a Supreme Court opinion saying that this regulation is valid. But in a circumstance like I described, you would be able to challenge it. Okay, so that's administrative law.
We should just skip this next one because nobody cares about it. We've
Yeah,
never
it's
talked
minor,
about it. Nobody
not
cares
important
about
case.
immunity. All we care about immunity from sicknesses. So let's just end now. It's been a great episode. We hope you guys still like us. Just kidding. Obviously, we're going to talk about Trump.
Trump versus United States.
And guess what, guys? This is not the first time we've talked about it. We've covered this before.
Did we nail it when we covered it?
Yes.
Yes, we did.
I mean, okay, here is the thing. I hope what you're taking away from this, you can disagree with us wildly. Perfectly fine. There is a lot of discussion to be had. We are flying through this because of that background whole concept. But remember, what we are trying to show you here, especially with Loper Bright, the Chevron deference case, and Trump, in those previous cases that we did, is not that we are such good psychic readers or even that we're that great lawyers, to be honest. It's that the reasoning was very clear what was being argued, because what was being argued legally is not necessarily what you're seeing in the news. This was not necessarily about if Trump could be prosecuted for this specific action. It was about the concept of executive immunity. Okay, with that.
Okay, so this was a 5-3-1 opinion. Justice Barrett was sort of off doing her own thing, which happens sometimes in these cases.
She's done a bit of that this term. I'm not going to lie.
She was kind of...
Justice Barrett, for those of you who may not know, is she the most junior? She's the most junior. No, wait, who's the most junior?
Jackson.
I'm so sorry.
Most junior.
Second most junior.
But Justice Jackson also has sort of like...
She also does, by the way, look, you say all you want. You know what? You're a justice. You do what you want. But Justice Barrett was a professor before she took the bench. And professors, for those of you who have ever had a professor, know that some really great ideas, and also they're not afraid to go off on their own in some of these. And in some of her opinions, you can really see the professorial background come out in that. So not saying any, comment on her going off into her own direction, but knowing their backgrounds is actually really helpful.
It was interesting because Jackson, in the oral argument about the Trump case, was basically the only person who said, maybe there's just no immunity whatsoever. And everybody was like, yeah, I don't know about that. But then when the dissents came out, they were much more along the lines of there's no immunity whatsoever than they were in the actual argument. This ended up, the majority said the president does have some immunity from prosecution after he or she leaves office. Immunity for, quote, official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. The dissent raised the SEAL Team 6 argument that Alito brought up in the argument. What if the president orders SEAL Team 6 to kill his rival and execute a coup? And we talked about this a little bit in the original discussion. I've talked about this before. Power at its extremes, it's kind of like physics at its extremes. It all kind of falls apart. Here's the thing. If there is a president who is going to order SEAL Team 6 to kill his rival and execute a coup so he can stay in power, he's probably not that worried about some potential post-presidency prosecution. I don't think that's going to be the thing that stops him from doing that, number one. Number two, if he manages to stay in power, everybody agrees that a president in power is absolutely immune from prosecution. No one disagrees with this, that's the case. You cannot prosecute the president while he's in office. So the only question is, does any of this survive when he or she leaves? And I think the point that the majority made was the counterexamples are really bad. This is the same argument that was made during the argument itself. The counterexamples are really bad, but the potential for problems you're going to have if you can prosecute a president are much more likely. And I want everyone out there to just think, do you think these scenarios should be allowed? Let's say President Biden raises taxes. Should a DA in an uber conservative state be able to charge him with theft and bring him before a jury in a state court charging him with theft? Now, he could argue all sorts of things, not really theft, it's government action, all sorts of stuff, but should he have to do that? Should he have to go before a jury and depend upon a judge or a jury honoring those arguments? Or should he be able to say, sorry, I'm immune. When I signed that law that Congress passed, that is an action within my purview. I am immune from that. Should President Obama be able to be prosecuted for murder for executing drone strikes on American citizens in Egypt? Should President Bush be charged with lying to Congress? Should President Clinton be charged with using his authority to try and start attacks that would bolster his political standing, particularly when he was in trouble with his wife over Monica Lewinsky? Should President Roosevelt have been charged with the fact that he imprisoned every single Japanese American? You may think he should be able to be charged with that. But nevertheless, should that happen? If the answer to any of those questions is no, then you believe in presidential immunity. You believe there is some limit to what you can charge a president with after they leave office. If you believe there's some limit, then you believe that this decision was right, whether you know it or not. The only way you can disagree with the decision in its totality is to think there is no limit, and any of those things I said can happen, and the president's just going to have to argue it in court. He's just going to have to convince a jury. He's just going to have to convince a judge. He's not going to be able to claim he's immune. And maybe that's the world you want to live in, but it's not necessarily the world I want to live in. I don't really want to see every president prosecuted by his political enemies every time he leaves office. And I think if that happens, it would be really bad for our democracy. So that's my position on it. I don't have a problem with this. If you want to argue about the specifics about which actions that Trump took that the court said he was immune for, that's fine. If you want to argue about that, you can. Most of this will be decided in an evidentiary hearing before a judge. Exactly.
Right? That is actually an open question. So those of you who have seen headlines that say Trump can do whatever he wants and he can't be prosecuted for it, that's not what the majority opinion says. I will say that's what the dissent says ultimately the opinion will lead to. And so that can be argued whether that will actually be the case. This opinion did not say full immunity, shield up, can't be prosecuted. It actually leaves a lot to the lower courts to decide which actions fall within that official core power purview. One thing to note about that, if there is no executive immunity, one thing is for certain: all presidents will be prosecuted by the other party, period. It will not be only those who have committed immense atrocities, because it will turn into a political war. That's why, even though Trump is in the case caption of this case, this is not about Trump. This is about the office of the executive. And we do not live in a democracy where the president can serve for more than 2 terms. So we do not live in a place where someone can serve forever. They will not be president forever. They will leave office after 2 terms or fewer terms than that. And so what we're looking at is the alternate world, which is one in which an executive, whoever that leader is, choose your leader, your favorite leader, put them up there. They don't even have to be running for president. I don't care. Whoever you're thinking of as president, if there is no executive immunity, number one, 100%, they will be prosecuted. What that will affect is not just that individual person. That will affect our entire country. That person's ability to actually make decisions on behalf of the country in that executive role, things that we may not understand. Like, look, I've done national security cases, and I only know a fraction of what actually goes into this country's national security. And the little bit I know terrifies me. But I certainly don't know enough about nuclear codes and when to call in the snipers, etc. Those are things that we have said the executive has power over. And if they can't do those sorts of things that could potentially affect the political stability of the world, that is a problem for the entire country, potentially for the entire Western world or beyond, because of our kind of role in international security and stability. These have implications far beyond just, do I like this guy or not? Or gal, whoever is in that position. So that is the basis and the kind of principle underlying executive immunity. It's not, I want to give my guy a, get out of jail free card because I like him. That's not what it's about. It's something much, much bigger than that. It is about the stability of our democracy.
And it's like everything else. President Trump has been charged in various different things. If this decision had been different, I just have no doubt. If President Biden doesn't win in November, somebody in this country would have charged him with something. I mean, that's the other thing. There's a lot of prosecutorial authorities here. You know, I mean, President Trump was charged in New York. He was charged in Georgia. He was charged in Florida. He was charged in D.C. There's a lot of different places that could charge somebody with things. And even if you think they're frivolous charges, the question is, do you want this to happen just continuously whenever you have a president? And if you think, like I said, if you think there's anything the president can do and not be charged for later by somebody, if you believe that, then you believe in executive immunity. That's just all there is to it. And I think given that the president is imbued with awesome authority in the Constitution, you probably believe in it. Now, you may be saying to yourself, yeah, but Trump's different. What he was doing was beyond the power of the president, and it was all for personal gain. That's fine. That's a great argument to use for why he doesn't get immunity for those actions. But it isn't a statement that there is no immunity. Those are two different things. And I feel like the dissent talked a lot about, like, you know, this was treason and this was all these other things. Okay, fine. Argue that in front of a district judge and say, we can charge him with these things because they went beyond his lawful authority as president. If you do that, you can escape the immunity block. But if you're trying to charge him for something that is within his presidential authority, I think he has immunity. I think President Obama had immunity. I think President Biden has immunity. I don't think this should be a party thing. And I think it's turned into a party thing because it's Trump. And Trump divides everybody, right? And I totally get that. It would have been better, frankly, if this had been somebody else. If somebody tried to charge Bush with something or Obama with something, that would have been better. But unfortunately, it was Trump, and that's what we're looking at. And so that's how it's decided, and it's called a lot of division. But the simple legal question, I think, is actually pretty straightforward. And honestly, I'm kind of surprised they couldn't come up with a way to make this unanimous. You know, earlier in the term, when Colorado wanted to keep Trump off the ballot, they were able to come to a unanimous decision there and say, we're not going to do this. For really many of the same reasons we're talking about now. Because they recognized that if you could do that, it was going to become a tit-for-tat thing. And all of a sudden, you were going to have red states keeping Biden off the ballot and vice versa. And they were able to come to that 9-0 decision. And I think that was really important and really good that they were able to get there. It's unfortunate they weren't able to get there here. I think a more narrow decision probably would have been better if they could have gotten to 9-0. But maybe at the end of the day, they just couldn't do that. And this is where we ended up with this 5-3-1, where you have the majority saying there's at least some immunity, Justice Barrett doing her own thing, and then the other three justices saying, essentially, there's no immunity for presidents after they leave office. But if you want to hear more about that, episode 102 is where we covered that before.
There you go. Okay, so we haven't touched on anything hot whatsoever, so I thought we'd talk about the Second Amendment, and that would be the case United States versus Rahimi. Now, this is an 8-1 decision, so near unanimous, and in this case, the court said the federal government can criminalize possessing a firearm while under a domestic violence restraining order. In other words, this is restraining your right to owning a firearm. Specifically, it was someone who had domestic violence charges against them. They were found to be, a violent person. And in a search of their home, a firearm was found, and they were charged with possession of that firearm. And this person challenged whether he was allowed to have it because of the Second Amendment. Now, this came from the Fifth Circuit, and the Fifth Circuit, the reason it went for the Supreme Court, held that there could not be such a restriction. And ultimately, it came down to whether there were corollaries from the founding fathers in terms of what types of restrictions we recognized before. And the Fifth Circuit they were trying to implement another Second Amendment case that came a few years ago, Bruin. And essentially, they were like, this was not a restriction that we saw before. And the Supreme Court essentially said there's not going to be perfect corollaries. We're not going to do perfect corollaries because we don't live in the 1700s when the Constitution was written. And we have always said if someone is going to be a threat, we can disarm those people. So 8-1 decision, not too surprising.
And this was really important because there had been all sorts of challenges to various laws. Felon in possession of a firearm, various misdemeanor cases in different courts had said, we're going to say that this went beyond what's allowed by the Second Amendment. And it was strange because the Supreme Court had been very clear really, ever since Heller, that this was about law-abiding citizens and their right to bear arms. But it was an interesting flip, actually, because what you saw were a lot of public defenders, defense attorneys really grabbed onto the Bruin decision, which was about whether or not law-abiding citizens can have a firearm in New York, and said, "Hey, this is law-abiding. What are you talking about? This is a right of the people, and that includes people who are under restraining orders for something like this, who are under indictment." Felon was probably your strongest one because you've been convicted of something. And essentially the argument here was you haven't been convicted of anything when you're under a restraining order. A judge has found that you should be under the restraining order, but you haven't been convicted of anything, so should you lose this right? And the court said, look, there have always been restrictions along these lines, and we're going to allow this restriction to continue. And this really should put a stop to those arguments about various federal laws that prevent various people who shouldn't have firearms from having them. So it was an important decision for that reason. And the last one we're going to talk about today is Net Choice versus Paxton. Now, we talked about this all the way back in episode 21, almost 2 years ago. And we told you that this issue would end up for the Supreme Court. For those of you who've forgotten, because it's been 2 years. So this was two statutes, one out of Florida, one out of Texas. And the statutes essentially said that large platforms, Twitter, Facebook, that sort of thing, were common carriers. They were the public space, even though they were private, and therefore they could not restrict speech. So they could not prevent various people from using their platform to speak. And the Fifth Circuit said that law is fine. The 11th Circuit said you can't do that. It goes up to the Supreme Court, and the Supreme Court, in a classic move, reversed both of them. And said,
in a unanimous decision, no less.
Unanimous decision, 9-0, with Kagan writing, sent them both back to the 11th Circuit and the 5th Circuit to basically do it over again. And here's the thing. Here's what I thought was interesting about this is Section 230, which is a statute, federal statute that gives protection for large social media platforms. Basically says there's a safe harbor if you're hosting stuff and something happens on your site, say there's a copyright violation, you are not liable for that because it's not your speech. You're just hosting it. It's not your speech, so you can't be held liable for that. What I think is really interesting and what I hope is examined more on these lower courts, the Supreme Court talked a lot about how there's a problem here. The speech that you allow on your platform is in many ways your own speech because you're allowing the speech or not allowing the speech. That is speech in of itself. If you say as Twitter, we don't want these kind of messages on our platform, that is speech in a real way. That is you putting forward your view of the world by preventing other people from being able to speak on your platform, which makes a lot of sense. We talked about that in the episode. The problem is when you avail yourself of 230, you're essentially saying, this is not our speech. We're just hosting it. We're throwing our hands up. So I think there's a really interesting question about the distinction between speech that falls within the safe harbor for 230 and speech that would not fall within the safe harbor, and whether or not the First Amendment applies in different ways given the kind of speech that you're allowing or not allowing, and whether or not there should be sort of a trade-off there, that if you're going to take advantage of 230, does that mean you can't rely on this argument? So I think that'll be an interesting thing to see whether the courts deal with going forward.
So there you have it. I can't believe we actually covered all these cases. It will be very interesting to see, how these are applied. We obviously live in a system where these are not rules that are then applied like a math equation to every case going forward. The reason these opinions span dozens, if not even more pages, is because they explain the reasoning by which the case is decided. And that reasoning is then applied by analogy to all other cases that come before other courts. Obviously, it's the Supreme Court, so all the lower courts below them have to follow the type of reasoning. And that's why, sometimes you have to see how these cases are applied moving forward. And when courts, the circuit courts below the Supreme Court, maybe go off in a direction that was not intended, that's where you have correction in future cases. And that's why these cases we use this term a lot, which actually means nothing, is we say these cases talk to each other. And it'll be interesting to see how these courts develop over time. And it is not a guillotine that falls down and this is the end of all administrative law, etc. There's a lot more to come, and you can see it when you read these opinions. They are not meant to be these like draconian, this is the end all be all. Every single administrative law case that comes before you, the challenger wins. That is not what it says whatsoever. Every action that you say that a sitting president did is immune. That is not what the opinion says. Rather, it is a lot more nuanced. So if anyone is trying to tell you that this is the end all be all, we know how all these cases will turn out, that is actually not the case.
And I think what's interesting about the cases we covered today is that is absolutely true for all of these. The administrative law context, I mean, that is going to be developing. If you're into administrative law, which means you're a nerd like us, then the next 10 years or so are going to be fascinating. The way all of these cases shake out, how agency actions are reviewed in the future, how the court differentiates between legal analysis and more expertise-driven stuff. So, for instance, if a law says that an agency can regulate mercury, right, to a safe level, you're going to argue about what safe is, but once you establish what safe is, then the agency is going to have a lot of deference in how it applies that to reach that sort of within its legal framework. So that'll be interesting to see. The executive stuff, executive power stuff is always sort of bubbling up. This stuff goes all the way back to the Youngstown Steel cases and the power of the president, and when the president has great power and when he has limited power. That all comes through in this case, which are just fascinating historical stuff. The firearm stuff is still developing, Second Amendment stuff, exactly what the limitations are thereof. I think that's going to become more and more about this sort of law-abiding citizens thing and the right of law-abiding citizens to defend themselves. And that solves a lot of the issues that you've seen bubble up with some of these cases. And then obviously, look, the internet, it's been around for a while now, but we still don't know what we're doing with it. And how it interacts with things like the First Amendment is just a frontier unto itself. We see this, the number of times, for instance, that people want to charge someone for something they say on Facebook, for instance, right? Like, when does that become a threat? When is it not a threat? There's just there's vast space there that can be filled with law, and it's going to be fascinating to see it. And I think, we'll be here talking about the next Supreme Court term. I'm sure they'll have some more interesting cases that flesh out a lot of what we've talked about here.
So, if those of you who've been following this season of the Supreme Court or have been following all the seasons of the Supreme Court, now they are in recess for the summer and the new term starts in October. And that's kind of the rhythms of the court every year. A lot of the cases have already been granted to be heard oral argument. The vast majority have not been. So we have some inkling of what cases are kind of at the beginning of the term next year and the October term. But it's wide open next year, y'all. That's kind of the fun of the Supreme Court. Some of these cases, like the Trump case, I think, was granted for oral argument just 2 months before the end of the term. So sometimes we know well in advance when a case is going to be on the court's docket. And sometimes as things percolate up, are, emergent, they will be kind of late coming and we don't always know, which is why every season of the Supreme Court, honestly, this is not said in jest whatsoever, is really exciting, says one nerd to another.
I like how we're just going to the season now. We're just going with season.
I have fallen in love with this way of characterizing it. Maybe because I've watched way too much of season 3 of Bridgerton. So all I'm thinking about is seasons. But
it's like a telenovela.
I think it is helpful to think about it in seasons because there are definite rhythms of it. And you also call it that, right? It's like the OT, whichever term it is, you refer to certain terms as well. And obviously, clerks who serve at the Supreme Court, who do a lot of the research, the prep, helping to draft these opinions. Ultimately, obviously, the judges sign the opinions. They change over sometime in the summer, so each term has a new set of clerks as well. So there are rhythms to the Supreme Court that are kind of like seasons of a show.
Yeah, and if there's any cases we didn't talk about that you want us to talk about, there were more. There were several other interesting ones. There were
like 70, 80 cases total that were heard at oral argument, many more on the shadow docket. We've talked about the shadow docket before, but we've touched on a mere fewer than 10% of the cases that came out this season.
And we talked about digging a case. The case was digged, dismissed as improvidently granted. That happened. So there was some interesting cases. If you're interested in any of the cases that we didn't talk about either now or before, let us know. We're going to start trying to predict which case the Supreme Court's going to take, because I thought that it was funny to listen back to us on the Net Choice episode 2 years ago talking about how the Supreme Court was inevitably going to take that case and would decide the issue, and then they totally dodged it. Just dodged it. Yeah. So, that's
we were wrong
fun.
on that one.
We were wrong. We did not nail that one.
We are happy to say when we are wrong on things. But I mean, with that, Brett, it's been like, I know some people listen to us on like double speed. I don't think they can do that with this episode because we talked really fast to fit everything in.
Had to get it all in.
Do we want to do maybe a lighthearted question?
We haven't done a question in forever. Let's do a question.
We could end with a little lightheartedness here.
I feel like we've been talking so much lately that we haven't done questions.
I know.
All our Karen Reed episodes turn into like
2-hour episodes.
2-hour, yeah. Okay, let's see. There's so many regular episode questions. Okay, this person, Olivia Cruz, wants us to explain sheriff's departments and how they work and how they're different than city police and why they end up in so many true crime podcasts.
Do you know the answer to this? I was trying to explain to my... the answer is I don't really know, but I was trying to explain to my son how the sheriffs had the motorcycles because they're part of the county, because the city decided to use SUVs. And he kept asking questions just like Olivia is, and I couldn't answer a single one of them. He's like, doesn't the county watch SUVs too? And I was like, they have some.
Yeah, I mean...
It's like the county and the city, and there's obvious overlap in them. And I think the reason counties in general, I don't know that sheriffs necessarily mean counties. I know there are sheriffs out there who are going to correct us. But the reason generally, if you're looking at a county jurisdiction versus a city usually has tighter city limits, right? And a county typically covers the city plus surrounding areas. So just in terms of like geographic reach, especially when you're talking about maybe someone transporting someone from one location to another, maybe from the city to the city outside of the city limits in order to dump a body or something like that, it can draw in a greater geographic reach of the jurisdiction. And
look, all this is, you have to go back 500 years to figure it out, right? Like the sheriff
and it
of
matters
Nottingham.
By jurisdiction too. Like each one is just going to be like so idiosyncratic.
So sheriffs have sort of an older pedigree than maybe your local police. There's always been a note, you got to have somebody in the area who's going to execute the laws. But then you have cities like Alice was saying, and they're going to have city police, and those city police are going to have jurisdiction over the cities. Oftentimes, whoever's the chief of police in the city is hired by the mayor and is politically accountable to the mayor and can be removed or whatever based on that. Sheriffs are often elected, which makes them very different kinds of political animals than your police chief. I mean, oftentimes, police chiefs come and go. You can have sheriffs who are sheriffs forever, who become just fixtures, and they're like little kings over their area. So I think, to go to your question, one of the reasons maybe you tend to see that more, and this is not to say that sheriff's departments are somehow more corrupt than city police or city police are better, but you can imagine if you have somebody who's been sort of entrenched for a long time, you have a lot of the same problems that come when somebody's been in power for a lot of times. I mean, you can see things become kind of lax, and maybe that's why oftentimes you see that. There also is sort of a high concentration in certain sheriff departments. The Los Angeles County Sheriff's Department is famous for some of the things that have happened on its watch. So I don't know that it is really true that you have sort of a bigger problem with sheriff's departments than local police, but I get what you're saying, and I totally understand why you would say that just based on life. Okay, one last question. This one's tough, but I'll ask it anyway. This is from True Crime Junkie 365. As a parent who is not so ignorant to the evil in the world, what would you suggest to other parents they do to protect their children against the evil in the world without ostracizing them from their peers.
This makes me sad because you're right. I think both of us are currently still in the blissful stage of parenthood where our children are still actually young enough to be within. We all think we can protect our kids and it's a farce, but they are still young enough because they're kind of closer to toddlerhood than teenage years. I know it's going to get harder. What I've seen, I don't know that my kids will allow it, especially with the peer pressure part. And this goes to your secondary question of how do you not ostracize them, is I'm going to start the campaign now with all of the parents in all of our classes, starting from like kindergarten, to try and get all the kids off social media, to not have phones. There is so many dark places, and that is where predators prey on people writ large, but certainly children. All those apps and devices that help you track your kids are good. They are not perfect. They are 100% workaroundable by kids and predators, and we see that daily. So I don't know. I've already started having those conversations even with my like kindergartner about how other people are going to have things and access to things that we are not. And they like to watch over other people's shoulders if we're like at the doctor's office in the waiting room and a kid is playing a game. And I explained to them why we don't watch other people's screens either, because I can't protect them from that. And those are like hard and scary things to talk about at such a young age. But I want them to understand from like this early stage that there are things out there that are not for their good, that there are people actively working for their bad. And it's going to be on things that look innocuous. They look like a YouTube video. They look like a simple chat device to be able to message your teacher. And we've seen too much. We've just seen too much. When you've prosecuted a lot of child porn, you want to throw away every electronic device that ever exists. And one way I try to do this, and I'm imperfect, is I try to hide my own phone from my kids when I'm at home. So obviously I work on my phone a lot because that's where I do a lot of my work. My email's on my phone. But I try to show them that I am without my phone so that they can grow up without it as well.
Yeah, I mean, there is no good answer to that question. And I think all you can do is talk to your kids, try and educate your kids, but just the fact is they're kids and they're going to make mistakes and they're going to do things that put them in danger, unfortunately. And all you can do is the best you can do, and I think it's absolutely terrifying. And I wish I had some magic bullet. And if you've got a magic bullet, please let us know what it is, because growing up today, man, we didn't have these problems when we were growing up. These are new issues. And so I don't know. Like I said,
I will say this thing that I've seen a lot of parents implement with like older kids that I haven't had to deal with yet is the very least we will do. There will be no connected devices in anyone's room. There will be no computers there. And that was a rule for me growing up, mostly because no one had personal computers. Like there was a family computer in the middle of the kitchen where the like desk was, but there will be no phones. There will be nothing plugged in. Like you don't get to charge your phone in your room, because it's when you're alone that you can be susceptible to these. And look, I have gotten calls from basically all of my friends who have kids who are over the age of basically 6, who have good kids, who have had all these talks, who have all the Life 360s and all the apps that control everything on their phones. Almost every single one of them have had to call me because of some situation where their child was catfished. They sent naked photos of themselves to someone who completely fooled them, and now we're blackmailing them, who accidentally gave their information, and now things were circulating around schools, whether it was like nude photos or bank account numbers or some vicious lie about them that was really cutting to the very core of like who that child was. And these parents didn't know what to do, and they were coming to me for like legal advice of what recourse they could have. And my answer to them almost always, there's not much recourse at this point. And it's all about prevention. Not to scare you guys, but it's just, we've seen it in our line of work, and I've seen it in my personal life, right? Like I look at my phone all the time, and almost every day I will get a text from a friend who says, oh my gosh, this happened. My kid who would never do this did this, and they didn't know about it. What do we do now? So just know it's out there, and you're probably not immune. I know I'm not immune. That's what I've learned from this job is as much as I know I can't protect my kids from it. So what I need to do is like basically remove them from the situation.
Yeah. So on that lighthearted note,
let's go back to U.S. versus Trump.
Exactly.
Oh, well, this was fun, guys. Thank you for hanging with us. Thank you for always asking us these questions. I hope you continue to have these discussions, whether on our fan-run Facebook group, The Gallery, or by emailing us. Like we've always said, you don't have to agree with us. And guess what, guys? Having read all your very wonderful emails and direct messages, many of you don't agree with us. And that's great. Think for yourselves. Ask the questions. Have healthy debate. We are here for it. We love hearing from you. Let us know if there's something we haven't covered that you'd like us to cover, or if you disagree with us. We also appreciate it. Just be kind in how you disagree with us, because having healthy debate is the key to a healthy democracy. With that, Brett, is there anything you'd like to add?
You've said it so well, Alice. Absolutely. You don't have to agree with us. We love having these conversations with you. We hope that at least you have a little bit better understanding of what's happening and why it's happening, even if you don't agree with it.
Well, with that, thank you guys for hanging with us. You can reach out to us at prosecutorspod@gmail.com. Find us on Twitter, X, Facebook, Instagram, even TikTok, and probably some other social media I've forgotten, despite just telling you all not to have social media for your kids. Until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Okay.
Sorry.
Awesome.
Portends of great things to come.
Yes.
Listen to us about the Supreme Court, y'all.
Yes. We definitely should trust us when we tell you about the Supreme Court.
We sure know about regulatory law. We can even make our
go.
computers work. Oh, man.
Okay. Well, you ready to
A
go
lot
then? You
happened.
wanna do this?
A lot happened this season. I was going to say season. This season of the Supreme Court. This season, will the court shock us again?
Yes. Always yes. Okay.